The Norwegian Saleform, an overview. The Norwegian Saleform 1993 is currently the most widely used and internationally recognized standard agreement for the sale and purchase of second-hand tonnage. Despite its wide use, feedback from the industry indicated that the Saleform could benefit from an update. PIMCO and the Norwegian Shipbrokers Association (NSA) therefore set about the challenge of revising the standard agreement. The result is the introduction of the Saleform 2012. The general principles and structure of the Saleform have been retained. However, amendments have been made to better reflect industry practice and to clarify certain issues prone to ambiguity or dispute. In this article, we shall consider the main amendment incorporated into the new Saleform 2012. Preamble. The preamble has been subject to some minor amendment, but the revision has no wording to reflect the common practice where a buyer or seller provides a performance guarantee in respect of its nominated buying or selling company. In light of the requirement for a valid guarantee under English law, such standard wording setting out the extent of the guarantee and calling for the signature of the guarantor may have been beneficial by limiting dispute concerning the validity of guarantees. A signature box for any guarantee can of course always be added as necessary. Definition. A number of additional definitions have been included in the revised Saleform, the most striking being the definition of class as the class notation rather than the classification society itself. Sellers will now be required to insert the class notation into the Memorandum of Agreement (MOA), a practice which is currently rare and which sellers usually avoid in order to prevent possible misdescription claim. It is notable that the definition of in writing hasn't been linked to the new notice provision at Clause 17. The deposit, Clause 2. In order to take account of commercial practice, the parties are now free to insert the relevant percentage of the purchase price which will be paid by way of a deposit. However, the traditional 10% remain as the default level of the deposit if no other figure is inserted by the parties. An interesting amendment is the new reference to a deposit holder, which is a move away from the assumption that the deposit will always be held by the seller's nominated bank. The deposit holder can be any third party, be it the brokers, lawyers, and etc. One of the most significant alterations to Clause 2 is the revised wording setting out the trigger for payment of the deposit by the buyer. The Saleform 1993 provides that the deposit be paid within a certain number of banking days from the date of the MOA. The number of banking days allowed for payment is open to the parties to agree. The revised Saleform 2012 now provides that the deposit will be payable 3 banking days from signature and exchange of the original MOA and receipt of confirmation in writing from the deposit holder that the account has been opened. The time for payment under the clause is clear, but it is possible that this wording may give rise to difficulties of interpretation. The usual position is the absent indication to the contrary. The broker's recap is evidence of a binding agreement having been reached, provided all terms have been agreed. It is possible that this new wording will lead to argument that the agreement is not binding until signature and exchange of the MOA, though this way presumably not the intention of the drafters. There is also the added express obligation on the parties to provide the deposit holder with all documentation required to open the account. The failure by one of the parties in providing this documentation may have a considerable effect, as the deposit will not be payable until the deposit holder confirms that the account has been opened. There is no express provision dealing with the consequences of such a failure. Payment of the purchase price, Clause 3. The wording for the trigger for payment of the purchase price has also been altered. Buyers are now obliged to pay the purchase price within 3 banking days of the date then notice of readiness (NOR) is given in accordance with Clause 5. The additional requirement in the Saleform 1993 for the vessel to be in every respect physically ready for delivery has been removed. The other significant development is the express confirmation that the deposit should now be considered as forming part of the purchase price. This deals with the interpretation given to the Saleform 1993 by the English High Court in Petty Berlian Laju Tankers versus Nusa Shipping. Time and place of delivery and notices. Clause 5. Clause 5 has been amended so as to include a date arranged for delivery by the inclusion for a date before which an OR may not be provided as well as a cancelling date. Sellers' obligation to keep buyers informed of the vessel's itinerary now requires them to give notice of when they intend to tender an OR. An OR is still be provided when the vessel is at the place of delivery and physically ready for delivery in accordance with this agreement. However, the well-known wording "in every respect" has been removed apparently in order to clarify that minor defect will not enable buyers to reject the vessel under the MOA. This arguably goes back to the position enunciated in the Action 1 Lloyd Rep 283. Where a seller indicates that the ship will not be ready by the cancelling date, the buyer's time for exercising their option whether to cancel the MOA or not has been reduced from 7 running days to 3 banking days. Driver's inspection and dry docking. Clause 6. Although the different alternatives for dry docking and inspection have been retained, the order of the alternatives in the standard form has been altered in order to reflect industry practice. Clause 6A has been amended so as to provide that buyers must exercise their option to require a diver's inspection at least 9 days prior to the intended delivery date. This seeks to ensure proper notice for sellers to make the required arrangement. Buyers should take note of the time limit to ensure they are not deprived of their right to call for a diver's inspection. Where a diver's inspection is required and conditions at the port of delivery are unsatiable, Saleform 2012 adds a provision confirming that the cancelling date shall be extended.